దూర విద్యా విధానంలో డాక్టర్ బిఆర్ అంబేద్కర్ ఓపెన్ యూనివర్సిటీ దేశంలోనే మొట్టమొదటి సార్వత్రిక విశ్వవిద్యాలయం. దాదాపు 2.5 దశాబ్దాలుగా దూర విద్యా విధానం ద్వారా కంప్యూటర్ కోర్సును అనుసంధానం చేస్తూ BA, BCom, BSc డిగ్రీ కోర్సులను అందిస్తోంది. పోస్ట్ గ్రాడ్యుయేషన్ స్థాయి, డిగ్రీ, డిప్లొమా స్థాయి కోర్సులను ఔత్సాహికులైన విద్యార్థులకు అందిస్తోంది. డెవలప్మెంట్ స్టడీస్లో సెంటర్ ఫర్ ఎకనామిక్స్ అండ్ సోషల్ స్టడీస్ ద్వారా ఎంఫిల్, PhDతో పాటు విశ్వవిద్యాలయమే స్వయంగా దూర విద్యా విధాన అంశంపైన PhD వంటి పరిశోధన కోర్సులు ప్రవేశపెట్టింది. సుమారు 4.5 లక్షల మంది విద్యార్థులు ఈ విశ్వవిద్యాలయం నుంచి ఉన్నత విద్యావకాశాలు పొందుతున్నారు. డాక్టర్ బిఆర్ అంబేద్కర్ సార్వత్రిక విశ్వవిద్యాలయం స్థానికంగా స్వయం బోధనా పద్ధతిలో ముద్రణ రూపంలో రూపొందించిన కోర్స్ మెటీరియల్ అందిస్తోంది. కోర్స్ మెటీరియల్ అధ్యయనానికి సహకరించే విధంగా రేడియో, టెలివిజన్ పాఠ్యాంశాల ఆధారంగా కార్యక్రమాలు ప్రసారం చేస్తోంది. అధ్యయన కేంద్రాల ద్వారా ఏర్పాటు చేసే సలహా సంసర్గ తరగతులు, సైన్స్ ప్రాక్టికల్ సౌకర్యాలు విద్యార్థులకు స్వయం అధ్యయనానికి ఒక చక్కటి అవకాశం. ఇవి విద్యార్థి సమీపంలో ఉండే అధ్యయన కేంద్రం నుంచే పొందొచ్చు.
Welcome viewers and my dear students to this teleconference on the topic Bailment and Pledge. This topic is drawn from the BCom second year program of the university. Contracts of bailment and pledge are a class of the special contract. Chapter 9 of the Indian Contract Act 1872 deals with the specifications regarding bailment and pledge. Sections 148 to 181 specifically deal with the contracts of bailment and pledge. A contract of bailment is a contract where one person called the bailer sends certain goods to another person called the Bayley for some specific purpose. We will know more about such contracts of bailment with two knowledgeable persons who are there with us. Mr. Srinivas, Director, Ships Academy. Welcome sir. And Mrs. Srimati Raghunandan, Senior Faculty, Bhavans Degree College, Sainikpuri, Secunderabad. At any time during the discussion, if you have any questions or you require further clarifications, please do call us. We would like to hear from you and also give you your clarifications on the following telephone numbers: 040 2703 1431, 040 2703 1432 and 040 2703 1433. Coming back into the topic, the very fundamental question I would like to ask Mr. Srinivas Rao. Sir, the most fundamental question, what is bailment and what are its essential features?
So, according to section 148 of the Indian Contract Act 1872, bailment is defined as delivery of the goods from one person to another person for a specific purpose upon a contract that goods shall be returned or disposed of when the purpose is accomplished as per the instructions or the directions given by the person who delivering them. The word bailment originally derived from the French word bailer. Bailer means to deliver. Here, what are essentials of the bailment? There are two persons, namely bailer and bailey. Bailer is one who is delivering the goods to another. Bailey is one to whom the goods are delivered. So, there are two distinct persons, namely bailer and bailey. There must be delivery of goods. The delivery of goods may be actual or constructive. What is the actual? Physically moving from one person to another person. Otherwise, acknowledgement of the delivery of the goods we can name. Physical transfer of the property. Here goods means again according to section 2 subsection 7 of the Sale of Goods Act 1930. That is every kind of movable property other than money and actionable claims, which means in case of a bailment, the goods means only movable property. It can never be immovable property. So, bailment is only for movable property. So, only goods are delivered from bailer to Bayley, that is possession of the goods are given, but not ownership on the goods. There must be purpose. Bailey can use the goods. Once a purpose is accomplished, the goods must be given back to the bailer, otherwise disposed of as per the instructions or the directions given by the person, that is bailer. Sunrise to sunset, without knowing the meaning of bailment, we enter into different types of the bailments. Only thing is, we haven't noticed that it as a bailment. To understand in simple, I have delivered my car for servicing. Myself is a bailer, service center is Bayley, purpose is service to the vehicle. The moment service is finished, the Bayley has to return it and claim the service charges. This we can label it as a bailment. One more simple example to understand. X delivered gold to goldsmith for making of jewelry. Here X is a bailer and Y is a goldsmith, we can call it as a Bayley. The purpose is delivery of gold from one to another for making of jewelry. Once jewelry is finished, he has to give back the jewelry and claim the making charges. Like this, sir, we can elaborate the concept.
That was a very, very beautiful explanation, sir. And it gives me a reason to ask you this. Now, you said that there are certain goods which have to be given to a person called the bailer for some specific purpose. Now, suppose I give my currency to the banker and the purpose is for safekeeping, and then after a certain period on demand, the currency has to be given back to me. Now, does this constitute a bailment?
Yeah, thank you, sir. But this is not a bailment. The very purpose is clear, sir. Bailment means delivery of goods. As already I mentioned earlier, goods means according to section 2 subsection 7 of the Sale of Goods Act, every kind of movable property other than money and actionable claim. As I rightly mentioned, money is not a goods. And one more contention you can say, I delivered my vehicle for servicing. Once service is finished, I can get back my own vehicle. But whereas if I give currency into bank for a deposit, there is no assurance I will get back my own currency which I gave it to the banker.
Okay.
So that is also one of the reasons wherein we can't call money depositing into bank is not a bailment.
So, money deposited into the bank is not called as bailment because the banker does not give you the same notes that you have deposited into your account back to you. That is the primary reason why it is not called a contract of bailment. Now, we will ask Madam. Madam, I can understand what is voluntary bailment. Voluntary bailment is bailment for a purpose. But Sir was also mentioning something called as involuntary bailment. What is involuntary bailment?
Basically, involuntary bailment is, suppose if I find anything, if I find the property of others which is not mine, I pick up that and I will make an effort to find the owner of that particular property and I try to hand over that good to that particular owner. Such action is called as an involuntary bailment. Without knowing that we are entering into a bailment contract, as Sir said rightly, that same way we enter into a bailment, it becomes our duty that to find out the true owner of that particular property and hand over the same to that particular person. This becomes an involuntary bailment. Apart from this, we have got many types of bailment. That is gratuitous bailment, where there is no consideration passing between bailer and Bayley, and non-gratuitous bailment, where there is a consideration passes from bailer to Bayley. So, sir has taken an example of servicing his car with the service center. For some service charges, it comes under the non-gratuitous bailment.
Okay. So, a bailment may be involuntary bailment where you do not carry out the bailment for any specific reward. No, that was a very nice explanation. Mr. Srinivas Rao, does the content of bailment impose any duties on the bailer?
Yes, sir. There are certain duties on part of a bailer. It is the first and foremost duty of the bailer to disclose dangerous nature of the goods. It is the first and foremost duty of the bailer to disclose the dangerous nature of the goods. As a bailer, before I deliver the goods, I have knowledge about the dangerous nature. I need to reveal the fact. If I don't reveal it, if there is any loss sustained to Bayley, bailer can get indemnification from the bailer. So, it is the first and foremost duty of the bailer to disclose known defects especially. Second thing, when you speak about to bear extraordinary expenses, ordinary routine expenses Bayley has to bear, because you are using the goods, you have to bear it, whereas extraordinary expenses bailer has to indemnify the Bayley. Again, try to recollect what is indemnity, nothing but making other person's loss good. X given his car to Y. X knew that his car brakes will suddenly fail. Nothing revealed before Mr. Y, and Y was incurred certain loss. Then he can file a case against a person, because you know the dangerous nature, you should have revealed it. Since you failed to reveal it, he will succeed for compensation. Second one, ordinary damages, extraordinary damages. For example, I gave my horse to my friend Rabindranath. Sir, you please safeguard my horse. Since he is safeguarding my horse for a couple of days, general maintenance he will bear. In case the horse suffered any serious ill health, if he had incurred any expenditure, that amount I have to reimburse to Mr. Rabindranath, because myself is a bailer, Mr. Rabindranath as a Bayley, incurred certain extraordinary expenses, it is my duty to reimburse. And the third important point is, in case of premature termination of gratuitous bailment, it is the duty of the bailer to indemnify Bayley. Gratuitous bailment means when no consideration is involved. To understand in simple way, I gave my car to my friend A. He can use my old car for 1 year. Since it is old car, in order to put into good condition, he spent 12,000 rupees. This is a gratuitous bailment. For using of a vehicle, he need not pay anything to me. After 6 months, I said, give back my vehicle. This is called premature termination of gratuitous bailment. He had already incurred the 12,000 rupees. Since he used the 6 months, so proportionately calculate, and the balance amount I have to reimburse with the bailer, Bayley. Yes, sir.
So, that was the explanation with regard to the duties of the bailer. Madam, one of the duties of the Bayley is probably to return the goods back after some purpose has been achieved. Like how sir was saying that the car is given for servicing, and after the servicing has been done, it has to be returned back.
Yes.
Now, just a hypothetical question. What happens if the Bayley fails to return the goods to the bailer?
Under section 160, it imposes the Bayley, that is, it is duty of the Bayley to return the goods to the bailer as soon as the purpose is accomplished or when the time, according to the expiry of the time, he has to return the goods to the bailer. That is his duty. He has no right to retain or keep the goods that has been delivered to him and waiting for a demand from the bailer. If he is going to fail to return the goods to the bailer, then he is added with the responsibility of indemnifying the bailer for any such loss or deterioration that has arisen for the goods that has been bailed to him.
Okay.
So, he has to make good such loss to the bailer. If in case he has not returned the goods to the bailer and any deterioration has been happened to the goods, he has to incur such loss on behalf of the bailer.
I would like to give one simple
Yes, sir,
example for
please.
the same point.
Yes, sir.
For example, I have delivered my car for servicing, as I mentioned earlier. Instead, I will give the delivery of the vehicle within the 48 hours. After the due time is completed, service also done, I repeatedly demand for the return of the vehicle. There is an unreasonable delay on part of the bailee in returning the vehicle. In the meantime, there is a short circuit of a power at a service center. If a vehicle got damaged, then it is the duty of the bailee to indemnify the bailer.
Okay.
After the reasonable time, the time is already elapsed, you are supposed to return my vehicle. Repeated demand for the return of the vehicle, bailee was neglected. So that I will succeed against a bailer for compensation.
In the same way, sir, can you tell me what are the other duties of the bailee also?
Yes, sir. It is the first and foremost duty of the bailee to take reasonable care of the goods bailed to him. If it is my own property, what amount of the care I would take, similar amount of the care and concern should I have taken in case of the bailed goods also. Bailed means delivered. If it is not my property, what care I would take? Similar amount of the care you should have taken in case of a bailed property. If there is any negligence on part of the bailee, he should indemnify the bailer. So, first rule is, it is the first and foremost duty of the bailer to indemnify in case of any carelessness handling of the goods by the bailee. Second duty is, bailee must not mix the goods with his own goods. Bailee must not mix the goods with his own goods, because one or other day he should give back. Later part, madam will explain more about on this particular topic is concerned, maybe the situation demands.
So, in the same way, madam, the later part, duty not to mix the goods of the bailer with his own goods.
Yes.
Now, again another hypothetical question, what happens if he mixes the goods without the consent of the bailer?
If he is going to mix the goods without the consent of the bailer, then in what proportion the goods have been mixed, if he can identify his own goods as well as the bailer goods, if that is possible, then he can divide and separate the goods, and for separation of such goods, whatever the expenses he is going to incur, he has to bear such expenses. If in case he is not able to find out properly the mixed goods, he has mixed it unauthorizedly and he is not able to locate the goods of the bailer as well as the bailee, in such a case he has to authorize his goods by giving
he has to separate the goods, and then whatever costs are incurred for separation, they have to be borne by the bailee.
And in case the bailee has mixed the goods, no, in such a case the bailer has a claim for compensation from the bailee. For so it has happened. He can claim for compensation.
Yeah, in other way I can put this one.
Yes, sir.
Thank you, ma'am. Bailee must not mix the goods with his own goods. Fundamental rule. Rule this is, because one other day how to give back. There are some assumptions for this rule. With prior consent from the bailer, I can mix the goods with my own goods. Assume you are a bailor, Mr. Rabindranath, myself is Bailey.
Yeah.
With your consent, I can mix the goods with my own goods. Second exception is when the goods are heterogeneous by nature, not homogeneous.
Okay.
They can mix up the goods. But the separation cost in case of the homogeneous should be borne by the Bailey himself. It's a duty sum. So with permission from the bailor, I can mix with my own goods. Otherwise, when goods are heterogeneous by nature also, I can mix up because separation become easy for me. I can bifurcate and give back the goods to the bail.
Okay.
That way I can.
So, one of the essential duties of the Bailey is that he should not mix the goods of the bailor with his own goods, and if by chance he mixes the goods of the bailor with his own goods, then he has to bear the cost of the separation. That is what sir was telling us.
And a few more
Yes.
points to add for this.
Sir.
So, Bailey must not take adverse title on the goods.
Okay.
Only goods are given to Bailey, but not ownership on the goods. He must not take any adverse title. For example, I gave my vehicle to you. You can use it for 10 days. Within 24 hours, you put one board, car for sale. Means you are taking a wrong title, adverse title over my property. In a bailment, only goods are given to Bailey, but not ownership on the goods. You are trying to sell means you are taking a wrong title. It's not the right. One more thing is, Bailey must not misuse the goods. I have given goods for a purpose, use for the stated purpose only. It is the duty of the Bailey that he can't misuse the goods. What purpose I have given, for that purpose only should use, later should give back the goods.
Okay.
These are also another points you can add.
Okay. All this while we have been only talking about duties, but how about rights, sir?
Yeah.
What are the rights of the bailor?
Rights of the bailor. It is the first and foremost duty of the person to reveal the known defects, I said.
Okay.
Come to the bailor side, duties and rights point of view.
Yeah.
I gave the goods as a gratuitous goods, gratuitous bailment. No consideration is there. Once the purpose is accomplished, I will ask the person, give back my goods. Right to recover back the goods in case of a gratuitous bailment. At any point of time, gratuitous bailment can be terminated. You need not wait until the purpose is accomplished, because no consultation is involved between both the parties.
Okay.
One more is, in case of a inconsistent use of my goods, then bailor got a right to recover back the goods. Lapse of the time, I have a right to ask the Bailey return my goods. This you can speak some from bailor side.
This might happen when the bailment is for a specific purpose.
Yes, sir.
So when the bailment is for a specific purpose, after the purpose is accomplished, the bailor has got a right to ask for the goods back.
Sir.
Okay. In the same way, madam, could you please tell me what are the rights of the Bailey?
Yes. Enforcement right. In case the Bailey has sustained any loss, the Bailey can sue for duties of the bailor. Second one is bailment by several joint owners.
Okay.
If the bailment is done by several joint owners, in such a case, the Bailey can take any one of the direction of the joint owners and he can return the good to any one of the joint owner, irrespective of taking the direction from all the joint owners. So, he can emphasize on that. The next one is he has got the right to compensation, right of compensation. Section 64 and 66 deals with this. Here, if the bailor has no right to bail the goods or to receive them back or to give instructions regarding them, consequently, the Bailey is exposed to some loss, then bailor is responsible for the same. If the bailor has no title to the goods and the Bailey in good faith delivers them back to or according to the directions of the bailor, the Bailey shall not be responsible to the owner in respect of such delivery. He has got right to remuneration. In case of non-gratuitous bailment, the Bailey has got right to claim for his remuneration as soon as he has accomplished the purpose of the contract or as soon as the expiry of the time given to the Bailey is done. Right to claim damages. See, damages we would like to understand, it is nothing but a monetary compensation given to an aggrieved party. So, Bailey can claim for such damages, as sir has rightly said that bailer's duty is to disclose the defect on the goods that has been bailed to the Bailey. In such a case, if the Bailey has to incur any loss or damage of such defective disclosure, then he has got a right to claim for such damages from the bailer. Right to sue.
Okay.
Bailey can sue any person who has wrongly deprived him of the use or possession of the goods, bailed or has done them any injury. His remedies against wrongdoers are the same as those of the owner. An action may therefore be brought by the Bailey or the bailer. He has got right of lien.
Okay.
I think sir will explain about the lien, different types of lien.
Yeah. Now, because madam has asked you to explain, sir, could you please explain the right of lien?
Yeah. Lien means retaining the property belonging to another person. I am retaining the property belonging to another person is called as lien. There are two types of liens are there. Particular lien, general lien. Particular lien according to section 170 of the Indian Contract Act 1872. Any person who can retain the goods only for unpaid balance where he put up some labor and work against such goods.
Okay.
For example, I delivered my watch for the repair. Repair charges are 1000. Unless until I pay the repair money, the repairer can exercise the lien. Means he can retain the watch until payment is made, because he had already exercised some skill and labor over my watch. Other one as a general lien. A person can retain the goods belonging to another for the settlement of general balance of account. Not only for that particular activity, subsequent any amounts dues also there, they can exercise. To understand who got a particular lien, who is having a general lien. Particular lien will be exercised by Bailey, pledgee, agent, auctioneer, unpaid seller and finder of lost goods. All these persons lien as a particular lien. General lien, banker, policy makers, attorneys will exercise the general liens.
General lien. Okay.
For subsequent dues also. That's why we are using one word for the settlement of general balance of account. Subsequent dues also they can exercise the lien over that.
Okay.
Yes.
So, the right of a lien is the right to retain the possession of the goods on which certain work has been done. Now, this specifically will tell us that the right to retain the goods will be available only when the possession is there in the person to whom the goods are bailed. Now, before I ask madam about the finder of lost goods, we have a caller online. Hello? Yeah, tell me, sir.
Hello? Hello?
Hello?
Hello? Hello? Good afternoon, Anil.
Good afternoon, చెప్పండి.
Hello, నా పేరు శ్రీదేవి అండి.
Okay.
I'm calling from Secunderabad.
Yeah, tell me, madam.
Actually, I just wanted to know, in detail about the bailment అండి.
Okay.
So, can you just explain me about that?
About what, madam? About bailment?
Yes, about bailment.
We have been trying to do just that for the past half an hour or so, but again for your benefit I will explain what is bailment to you. Bailment is a contract between two persons. One person is called the bailer, the other person is called the Bayley. The contract between them would be for a specific purpose. Now, in a contract where one person called the bailer delivers certain goods to another person called the Bayley for some specific purpose, that they shall, after the work has been accomplished, be returned back to the bailer or may be disposed of according to the directions of the bailer. The contract between them is called as a contract of bailment. For example, say I give my watch, or for that matter to keep in time with the times, if I give my mobile phone to a company for repair. Now, here I become the bailer and the goods are the mobile phone in this case. These mobile phone is given to the company which is called the bailer in this case, and the reason why I am giving these goods is that there is some repair to be carried out on them, and after the repair is done, the goods have to be returned back to me. Now, in this I am called the bailer and the service center of the company is called the Bayley, and this is a contract of bailment. And after the mobile phone has been repaired, it has to be returned back to me. Now, here comes the question whether it was a bailment for payment or a bailment not for any payment. If it is a bailment for payment, then only after the charges have been paid by me, the mobile phone will be given back to me. Here again we have come up to a point where we said that if the bailer does not pay the charges, what would be the situation? That situation will lead to what is called as lien. Lien is a right to retain the possession of the goods until the price has been paid in respect of them. So, here if I, the bailer, refuse to make the payment of the repair charges, the Bayley has a right to retain, that is keep in his possession the mobile phone until and unless he has been fully paid for. This is called as lien, and we have explained this up till here, and then we would want to take this further and ask Madam, could you please tell her the position of the finder of lost goods?
Yes, already we have understood this as an involuntary bailment. If a person finds any such good when he come across while he is walking on the road, he takes possession of such good and he cannot claim it to himself that he is the owner of such goods. Such a person is called as finder of lost goods.
Okay.
For example, if I am walking on the road, if I could find a wallet of some person lying on the road, I pick up that wallet and I cannot say that that wallet is mine.
Okay.
It is my duty that I should verify with the details in the wallet to see the true owner of that wallet and see that it reaches that particular person.
Okay.
So, this sort of bailment is called as involuntary bailment, and in this case I would like to say here sometimes the finder of lost goods.
Ma'am, I am sorry, I will get back to you, but when, because the callers are important for us, we have got another caller. Hello.
Hello.
Hello. Yeah, tell me, madam.
I am Anusha calling from Dilshuk Nagar.
Tell me, madam.
Good afternoon, ma'am. I just have a small doubt. May I know what exactly a pledge is?
Pledge. Okay. Mr. Srinivas Rao would like to answer this. In case you specifically wanted to ask madam, but then I want to ask Professor Srinivas Rao, what is pledge?
Yes, sir. According to section.
It's not just madam out there. Even sir can answer it. It's just
Yeah.
a general question since I have this in the portion next year. So
Thank you so much.
Know what it is.
Thank you so much,
Yeah.
Anushka, for asking. Sir is explaining.
Yeah. Pledge. According to section 172 of the Indian Contract Act 1872, pledge is defined as bailment of the goods from one person to another person to discharge the promise or as a security for the debt. In a pledge, there are two persons, namely pledger, pledgee, or pawner, pawnee. There are two persons are there. Pledger is nothing but like a bailer. The person who is delivering the goods is called pledger, pledgee, to whom the goods are delivered. So, there are two persons, namely pledger, pledgee, pawner, pawnee. There must be delivery of the goods. Here only goods are delivered, but not ownership on the goods. Goods are delivered as a security, not for personal use. Do remember, pledgee can never use the goods. Goods are delivered as a security, surety, in case of default by pledger on maturity. In case a pledger failed to make the payment, pledgee can sell the goods after giving a reasonable notice.
Okay.
Simple way to understand, loan against security, nothing but a gold loans are there. I approached the bank, I want some loan. Bank said, pledge something, take the loan. I delivered my gold to bank, borrowed some loan. Myself as a pledger, banker as a pledgee, and delivery of gold from one person to another person. Purpose is to secure the loan. When I paid the money, the bank will give back my gold. In case if I commit a default, banker can dispose the gold after giving reasonable notice to the pledger.
Okay.
Again, pledge is only movable property, and pledge is one type of mortgage only, and it is against only movable property but not a immovable property.
So, pledge is a kind of security, and pledge is a contract where goods are bailed for the purpose of security. And do we have another caller? Hello? Hello? Yeah, tell me, sir.
Good afternoon. Thank you for giving a good lecture for the past half an hour.
Thank you.
And I would like to congratulate Mr. Srinivas who has given good lecture along with good details about the concept and all.
Thank you so much, sir.
Mr. Srinivas, I would like to ask one question regarding what is meant by actionable claims. You said already that bailment is not applicable in case of actionable claims.
Yeah.
Can you briefly explain what the concept of actionable claims?
The caller here was asking Mr. Srinivas Rao to specifically tell him what is the meaning of actionable claim, because you had mentioned
Fine.
that
Yes, sir. Yes, sir.
except other than actionable claim and money, you mentioned.
Goods means every kind of movable property other than money and actionable claim. Actionable claim means when the debt is matured, if opposite person is not honoring the payment, through court of action, I can realize that money. We can label it as actionable claim. In simple to understand, a bills of exchange, promissory note or check. These three are called actionable claims. If debt is matured, in case of dishonor of these instruments, I can realize this money through court of action. So, they are called negotiable instruments, they are not for sale.
Okay. Yeah. So, that was actionable claim, and madam was trying to explain, rather I deliberately use the term trying to explain because we had callers, as she was talking about finder of lost goods. Ma'am, continue.
Yes, sir. So, we understood the concept of finder of lost goods. Let us go ahead with understanding the rights of the finder of lost goods. Section 168 provides the following rights of the finder of lost goods. First one, he can retain the goods until the compensation and trouble he has taken to find such good and to find the true owner to whom that it can be handed over. So, this right is known as finder's lien on goods. The next thing is, if the lien extends till he is paid the compensation, the finder cannot sue the owner of the goods to recover the expenses incurred by him.
Okay.
In case the owner has offered any specific reward for the return of goods, the finder may sue for such reward and he may retain the goods until such reward is paid.
Okay, ma'am, at this juncture, I'd like to stop you and take another call. Hello.
Oh, yes.
Hello. Yeah, చెప్పండి సార్.
I am Ravichandra. I am from Shimshabad.
చెప్పండి.
If we purchase goods from a market, what consumer protection act tells?
You are asking us what is Consumer Protection Act?
Consumer Protection Act, sir.
I'm so sorry, we would be happy to answer it, but then we would take questions only with relation to bailment and pledge, because this particular discussion is on bailment and pledge. Consumer Protection Act is a different thing altogether. So I'm so sorry, I'm not able to get back to you on that. Madam, finder of lost goods.
Yes, the last right the finder can exercise is, with all the efforts he has made to find the owner of that particular goods, he is unable to find that particular owner. In such a case, if the goods are perishable in nature,
Okay.
then he can sell the goods and he can convert that good into a value. If in that case, he can take the value and he can retain the value if he is unable to find the owner of that good.
Okay.
The second thing is, if the lawful charges he has incurred for finding the true owner and that amount is 2/3 of the value which it is going to be on the claim, he can retain such goods.
Okay.
Yeah, to sum up this
Yes,
finder
sir,
of
please.
lost goods, never mind, just to add some clue, just a summary to this one. Finder of lost goods and always 3 sections you can remember, sir.
Okay.
Section 71 meaning, 168 right of lien, 169 is sale of the found goods. What is section 71 meaning? What is the meaning? Any person who finds the goods belonging to another took into those goods into his custody is called as finder of lost goods. As madam rightly mentioned one example, I find a wallet belonging to X. I took into my custody. Myself is called as finder of lost goods. According to section 168, right of lien, the person who lost a wallet gave an ad in the newspaper. Anyone who returns my wallet, there is a reward of ₹1,000. By all the way, go to the true owner, ask him to pay the ₹1,000, then only can give the delivery of the wallet. Which means, if the true owner refused to pay the reward money, I can exercise lien.
Okay.
Lien means again retaining goods belonging to another.
Okay.
Particular lien we are talking about. That's why I said again, I will add this point. Particular lien, a person can retain the goods until reward amount is paid. If reward is announced, then only will get a right. If reward is not announced, I don't have any right.
Okay.
Second thing, 169, sale of the goods. As a finder of the goods, I try to trace out a true owner. True owner is untraceable or traced but not paying the legal charges. 2 ways it can be interpreted.
Okay.
First one, I traced the true owner, he is not paying the legal charges. I can sell the property. I can take my legal charge. How much legal charge? As madam was mentioned, 2/3 of the value found.
Okay.
Second option, the goods are danger of perishing.
Mr. Srinivas,
Yes,
so this
please,
finder of lost goods probably is lost in all the discussion, and also in the phone call we have got another caller.
Yes, sir.
Hello. Hello.
నమస్కారం సార్.
నమస్కారం అండి.
సార్ మామూలుగా మనం ఎప్పుడైనా జాతరలలో ఉంటాయి కదా సార్, కొందరు పుణ్యక్షేత్రానికి వచ్చే వాళ్ళు ఉంటారు కదా సార్.
అవును.
సార్ వాళ్ళు పోగొట్టుకున్న వస్తువులు అది ఎవరికి ఉంటాయి సార్?
ఇప్పుడు దట్ ఈస్ వాట్ వీఆర్ ట్రైంగ్ టు సే అండి. ఇప్పుడు మీరు శ్రీనివాసరావు గారు చెప్తారు, జాతరలలో ఏదైనా పోగొట్టుకుపోతే మరి అది ఏం చేయాలో శ్రీనివాసరావు గారు చెప్తారు. సార్
ఏం సార్, ఎవరికి దొరికిన వాళ్ళకి తీసుకెళ్ళి ఇచ్చేయడం మనం. అదే మనం చెప్తుంది ఇప్పుడు ఫైండర్ ఆఫ్ ద లాస్ట్ గూడ్స్ అని చెప్తుంది అదే సార్. ఏదైనా వస్తువు మీరు పోగొట్టుకున్నారనుకోండి, అది కనుక మాకు దొరికితే ఏం చేయాలి? ట్రేస్ ద రియల్ ఓనర్ కోసం వెతకాలి ఫస్ట్.
అవును సార్.
వాళ్ళు కనుక దొరకపోతే నియరెస్ట్ పోలీస్ స్టేషన్కి వెళ్ళి హ్యాండ్ ఓవర్ చేయాలి.
సార్.
ఒకవేళ డీటెయిల్స్ కనుక్కుంటే మీ దగ్గరకు వచ్చి మీకు ఇవ్వాలి.
సార్.
ఇచ్చేటప్పుడు లీగల్ ఛార్జెస్ ఏమైనా ఉంటే మీ దగ్గర మేము క్లెయిమ్ చేసుకోవచ్చు.
ఓకే సార్.
ఎంత క్లెయిమ్ చేయొచ్చు అంటే 2/3 ఆఫ్ ద వాల్యూ ఫౌండ్.
ఓకే సార్.
అంతేనండి.
ఓకే. సో అయితే మరొక విషయం అండి, అనదర్ వెరీ ఇంపార్టెంట్ థింగ్ ఇస్ ఫైండర్ ఆఫ్ లాస్ట్ గూడ్స్. యూ కెన్ సీ వెన్ సర్ వాస్ టెల్లింగ్ అండ్ మేడం వాస్ టెల్లింగ్, వెన్ యూ ఆర్ వాకింగ్ ఆన్ ది రోడ్, వెన్ యూ ఆర్ ఇన్ ఏ పబ్లిక్ ప్లేస్, ఇందాక మన కాలర్ అన్నట్టు వెన్ యూ ఆర్ ఇన్ ఏ జాతర, వెన్ యూ ఆర్ ఇన్ అన్ ఎగ్జిబిషన్. ఇప్పుడు ఐ విల్ టేక్ ఇట్ ఫర్దర్ అండ్ దెన్ సే, నేను మీ ఇంటికి వచ్చానండి, మీ ఇంట్లో నాకు వస్తువు దొరికింది అని మీరు అనొచ్చా? కెన్ యూ సే దట్ ఐ ఫౌండ్ సంథింగ్ ఇన్ యువర్ హౌస్, నౌ ఐ ఆమ్ ది ఓనర్? యూ కెనాట్ సే దట్, బికాస్ హియర్ sir and madam specifically said that finder of lost goods, when you are walking down the road and you see something shining on the road and you pick it up, now you can retain the possession in those goods against the entire world except the true owner.
Yes, sir.
Except the true owner, you can retain the possession against the entire world. In the same way, when you find something in a fair, in a jatara, you can pick it up, you can retain it against the entire world except the true owner. And the rule of law says that you should make efforts to find out who the true owner is. You just cannot say and wish that you will never find the true owner. The rule of law says that you have to find who the true owner is, and then you will have to return the good back to the true owner. Now, in the process, if you incur any lawful charges are those charges which can be easily ascribed or apportioned to the goods which are lost. And if these lawful charges, if the owner is not willing to pay the lawful charges, then you will have a right to sell off the goods and take your lawful charges. But here another important thing is, the lawful charges, are they more than 2/3 of the value of the goods or less than 2/3 of the value of the goods? And moreover, if you are unable to find the true owner and in the process your charges are more than 2/3, then you have got every right to sell off the goods. Now, maybe
Finally, you can conclude in
yes, sir.
1 second, sir. Finder of the goods is the next best owner to real amount.
Yeah, real owner.
As you rightly mentioned, sir.
Real owner.
Finder of the goods is the next best owner to real amount. He is an absolute owner of the property in absence of the true owner.
True owner.
Now, he can claim that property.
Yeah.
Just
And then the true owner also has to take the goods back only when he pays the lawful charges. Okay. So that was maybe we might have dealt about the finder of lost goods at a great length. Now I would like to ask Mr. Srinivas Rao. One of the callers, I remember, asked you about what is pledge, and she also said that she has got an exam which is due in the coming days. I would like to help the caller and then ask you what are the essential elements of pledge here.
I think I covered already. Just I remind this concept and again. Pledge is nothing but, according to section 172 of the Contract Act, delivery of, that is the bailment of the goods from one person to another person to perform the promise or to discharge the debt, which means goods are delivered as a security. There are two different persons here, namely pledger and pledgee, pawnee and pawnee. Pledger is one, like a person delivering goods to another. Pledgee is one who is delivered the goods. Pledger and pledgee, pawnee and pawnee. There must be delivery of the goods. Again, delivery of goods means physical transfer of the property from one person to another person, and only movable property can be pledged. Pledge is one type of mortgage.
Okay.
It is not a mortgage, one type of mortgage. And pledge is means goods are delivered to the pledgee as a security. Pledgee cannot use the goods. If the pledger commits a default on maturity, then pledgee can sell the goods after giving a reasonable notice to the pledger. And we are remembering earlier one example also, delivery of gold to bank, borrowed some loan. I need of money, approached the bank said pledge something. I delivered my company share certificate to bank, borrowed some loan. Myself as a pledger, bank as a pledgee, and delivery of the certificate from one person to another person. The certificate is delivered as security against debt. Once I clear the debt, certificate will be released. In case if I commit a default, banker can dispose of my certificate after giving a reasonable notice to the pledge.
Okay.
That we can speak about pledges.
So, all the while pledge you were mentioning that my share certificates,
Yes.
something which I have got.
Fine.
Now, is there a situation where I can pledge something of which I am not the owner? Is pledge by non-owners possible?
Pledge by non-owner, certain occasions it is possible. When pledge by mercantile agent.
Okay.
In agency, one rule is there. When agent is acting, means the principal himself is acting.
Okay.
Here the agent, mercantile agent means a person who is directly involved in the day-to-day operations of the business. On behalf of the principal, the mercantile agent can pledge the goods.
Okay.
Sale by, pledge by one of the several joint owners on behalf, in case of a partnership.
Okay.
All cannot be active partner. The active partner can pledge the goods on behalf of another.
Okay.
In case of a voidable contract, unvoidable contract also goods can be pledged. Pledged by the finder of lost goods until you find the true owner.
Okay.
Like this, a non-owner also can pledge the goods.
So, there are many ways in
There
which
are ways, yes.
even a non-owner
Yes.
also can pledge the
Yes,
goods.
yes, sir, yes.
Sir, when a contract of bailment is entered into, it says that something if it is created by a law. Before I clearly ask you this question,
Yes, sir.
I will take a call. Hello. Hello.
Hello. Hello.
Yeah.
Is there any difference between pledge and mortgage, sir?
Yes. We will try to answer that. Srinivas,
Yes,
sir.
Mortgage is against immovable property. Mortgage is always against immovable property. Pledge is against movable property. That's the only technically we can speak about. Originally, both are mortgage. We can use pledge is only movable property. By pledging the movable property, I can't say a mortgage rate.
Okay.
And vice versa. Land and building can't be pledged. It's only a mortgage.
Mortgage.
Like that.
Okay. So, the only difference between pledge and mortgage is pledge is of movable property and mortgage is of immovable property. Now, I was trying to ask Dr. Srinivas Rao. Now, here when any contract is created by the operation of law,
Yes, sir.
how will a contract of bailment be terminated? How do you terminate a contract of bailment?
Termination of bailment. Nothing but when does bailment come to an end, you can say. In simple word, when you understand, one, what purpose goods are given to Bayley? Purpose is accomplished. When purpose is accomplished, I gave my book to my friend for examination. Exams are completed. Give back my books. Bailment. Lapse of time. I gave my car to my friend. You can use it for 10 days. Time is lapsed. You have to give back my vehicle. Third scenario, when I gave the goods to Bayley on specific instruction that you have to use it. When there is inconsistent use of the goods, then I can terminate the contract and take back my goods. And the goods are destroyed. Whatever goods are given to the Bayley, the goods got destroyed. Then obviously, bailment between the bailer and Bayley will come to an end. And death of either bailer or Bayley, the bailment is automatically terminated. These are various ways. Okay. Expiry of time, lapse of the, nothing but the purpose is accomplished, inconsistent use or misuse of the goods, destruction of the subject matter. Otherwise, death of either bailer or Bayley lead to the termination of the contractual obligations between bailer and Bayley.
Okay. So, just to put it again, how is a contract of bailment terminated? Because we started this discussion with what is bailment, and then we will have to conclude this discussion with the in the same vein, trying to find out what is or how is bailment terminated. Now, bailment, if it is for a particular purpose, after the purpose is accomplished, the bailment is terminated. Like for example, the same example that we have been using right from the beginning of this program, when I deliver my car for servicing. After the servicing is done, it has to be returned back and the bailment comes to an end. That is how it is terminated. And when there is a lapse of time, if the bailment was for a specific purpose. Suppose I give my horse to B for his riding for 1 week. After the end of the week, the contract is automatically terminated. So, that is bailment termination on the lapse of time. And then when there is destruction of the property in goods, suppose for example, I give my goods as bailment. Now, when the property in itself is destroyed, if the subject matter itself does not exist, there is no point in the bailment existing, because the bailment is for is of those goods. When the goods themselves do not exist, the bailment also will come to an end. And when there is an inconsistent use of the goods. Now, in a contract of bailment, the bailer will specifically give the goods for a particular purpose. Now, if I say that I give my horse to B for B's riding only. Now, here I specifically said that I will give my horse to B and that B himself has to ride the horse. Now, if B gives the horse to C for his riding, then the contract of bailment, there is a variance in the terms of contract, and because of the variation in terms of contract, the contract will come to an end. So, where there is an inconsistent use of the goods, the contract of bailment also will come to an end. And one of the important means which everybody know is that the contract of bailment will come to an end upon the death of the bailer or the death of the bailee, because in the absence of parties to the contract, you cannot imagine a contract. So, the contract of bailment will come to an end upon the termination of the contract. We have got just some more time just to ask Mr. Srinivas Rao to sum up the entire thing in a sequential order for the benefit of our students, just in 2-3 minutes.
Yes, sir. First we started with bailment. Bailment means delivery of the goods from one person to another person for a specific purpose. Upon a contract, that goods must be returned or disposed of when the purpose is accomplished as per the directions given by the person who delivering them. In that we learned what are the essentials of the bailment, types of the bailment, rights and duties of the bailer and bailee, when does bailment come to an end. Then we have taken up the concept called pledge. In case of a pledge, again delivery of goods, nothing but a bailment of the goods from one person to another person for a purpose. The other purpose is as a security against the loan. Here also there are two persons, pledger and pledgee, pawner and pawnee, like delivery of goods as a security. Pledgee can never use the goods. Then we taken up the concept called finder of lost goods according to section 71, meaning any person who finds the goods belonging to another, took them into his custody, is called as a finder of lost goods. According to section 168, the lien of the finder of lost goods. According to 169, sale of the goods by the finder of the lost goods in case the legal charges were not paid. And then we discussed about the lien, particular lien, general lien, meaning as well as, and pledge by the non-owner. This is about today's discussion. To sum up, we can say, what is the difference between bailment and pledge? In case of bailment, there are two persons, namely bailer and bailee. In case of a pledge, there are two persons, namely pledger, pledgee, pawner, pawnee. In case of a bailment, goods are delivered for goods may be delivered for different purposes, but in pledge, goods are delivered for a definite purpose. In a pledge, pledgee can never use the goods, whereas in case of a bailment, bailee can use the goods. In bailment, bailee can never sell the goods unless otherwise authorized by the bailer, whereas in case of a pledge, in case of default by pledger, pledgee can sell the goods, like this.
So, that was a discussion on the contract of bailment and pledge. We sincerely hope and earnestly also hope that this particular discussion was useful for all our viewers, and at this juncture I would like to profusely thank Mr. Srinivas Rao and Mrs. Raghunandan for coming over to our studios and helping our students and ourselves.